is information that an employee garners through the course of the employment. So if you have proprietary, so it's not shared by everybody and it's not common knowledge, and the company has an innovative way of conducting business or has some type of innovative product, whether or not it's patented or not, or in the process of being patented, and you're, by the nature of the business, unless you're doing everything yourself, which is pretty rare, happens, but you're talking about in a scenario where you have employees, they're going to have to be exposed to that proprietary information, whether it's service or product or how to run your business. And so the question is how do you keep somebody from just leaving and taking that business or that proprietary information from the business to another company or start their own company up and compete with you? So you've given them the opportunity to work for you. You've given them this sensitive information to help your business, not to help themselves out personally, other than, as an employee of the company, that's fine. But if they leave the employ, then you certainly aren't under any obligation to try and help them out by letting them have all of your sensitive information. And also, too, it keeps other businesses from stealing employees or poaching employees because there are no intellectual property laws that are or terms that have been signed by the employee that are in place. So that's kind of the first part of it. The second part is that the business may, in fact, give an employee the opportunity to come up with something creative or proprietary. So it's not something that anybody else came up with, but the fact of the matter is that the way that the business is run, it gives an employee opportunities to be creative, to be inventive, and if you're a good business, then you encourage that because they may think of an idea that as an owner or a boss you haven't thought about. You might have somebody that's really an outside-the-box thinker that comes up with a great idea, and the company should be able to own that idea, even if the person that works there is the one that came up with it, because the company gave them the tools, the resources, the atmosphere, whatever support the company gives to be able to create those ideas and to encourage creation of those ideas. And if you didn't have intellectual property agreements that you could enforce, then as an owner, you're kind of in a catch-22 because you want your employees to take initiative and to do a good job and be creative and inventive. And at the same time, you do all that, and it may come back to bite you if they can just take that on their own and compete with you and destroy your business, or go to another business that competes with your business and ends up harming your business or destroying it. So that's why the intellectual property laws are in place, and it's a good idea to have your employees sign those types of agreement, unless you are in a business where you absolutely have nothing proprietary and you don't have any kind of atmosphere where people would come up with creative things that would help. In other words, they just do exactly what they're told, which is probably not a good business plan, but they are out there. And then you wouldn't need one. But in a lot of instances, it's definitely something that should be considered and discussed with counsel. And if you don't need one, then competent attorneys will say, you can have this, but you don't really need it based on the nature of your business. Or you need one, and you need a really, really tight one because this is going to be a problem, and I can already see the writing on the wall.